The long-awaited court case that has been in the Supreme Court has finally come to light. And by the way, let's say kudos to the judiciary of the Republic of Uganda, of course, courtesy of the Chief Justice himself, Alfonse or Chigamoy or Dolo. Well done. And by the way, kudos to all your team who are working tirelessly to see that Uganda, sees and believes and feels the justice that should prevail in that lovely country. And of course, the Attorney General versus Michael Kabaziruka's case has finally been put out. They are pronounced, they pronounce themselves pretty clear. The Supreme Court has declared that it is not right for a civilian to be tried in a court martial. And so all these cases that we are seeing of Dr. Colonel Kizabesige, and Obed Lutale, and all the other civilians who are undergoing trial in court martial of Uganda, they are not supposed to be there. So the Supreme Court has pronounced itself very clear, and so we look forward to seeing all of these civilians to be tried in the right court of judicature. And I hope in the near future we will see no civilian at all going to the court martial or the court martial, whatever, or the tribunal for the military, which is entirely supposed to be for the military people. And so I am excited. And finally, let's say bravos, kudos to the judiciary of Uganda, and of course, with the right leadership of the Chief Justice himself, not doctor, please pardon me. The Chief Justice is, I should say His Excellency. The Chief Justice, Alphonse Chigamoy Owindolo, with the right leadership, would love to see this, at play, that the rights of civilians will be respected and they will be put to the right court that are supposed to be having them arraigned before them, and they will have a fair hearing. And of course, one would argue that, justice delayed is justice denied. However, it took so long, but we would want to appreciate them for having, to pronounce themselves on the right track. And of course, those who are almost on the verge of giving up, who are not having the hope to see the light at the end of the tunnel, we will finally celebrate with all of us that no civilian will ever be tried in a court martial, which is entirely supposed to be for the military officers. And of course, this is enshrined in the Constitution of Uganda. And we'd love to see more of this in the near future. Thank you so much, guys. By the way, you could listen to this and then just be able to have a feel from himself. Uganda Law Society against Karugaba, that the military post to be truly independent and impartial, there are desirable changes that the executive needs to address in order for this court, in order for this to be applicable to the military courts, the article would have to be modified in such a way as to give the courts independence and impartiality without compromising their military nature. The army would have a parallel judiciary with legally trained soldiers to professionally man the courts. In order to be impartial, the court must have security of tenure and other privileges enjoyed by the other judicial officers in the Ugandan judiciary. It should be noted that the definition of judicial officer contained in Article 151 does not exclude persons exercising judicial power in military courts. Close quote. I consider the need for this recommended transformation as relevant today as it was then. In the premises, I would make the following recommendations for
for consideration by the executive and parliament as viable alternatives for the establishment and no creation of military courts in Uganda. These are recommendations. They can pick any, they can reject all, but these are recommendations which the people of Uganda hope to look into. A. Administratively establish the General Court Martial as a division of the High Court without the need to create a new court. With jurisdiction to handle capital criminal cases involving both military officers and any civilians who would exceptionally fall within its ambit, with magistrates within the division handling offences falling under their jurisdiction. B. Limit the functions of the unit disciplinary committees and summary trial authorities to handling strictly disciplinary offences with no power of imposing sentences or imprisonment. C. Utilize the existing magistracy to handle the rest of the criminal cases other than disciplinary offences.